Okay, so here we got the Fair Debit Collections Practice Act. So the way the Fair Debit Collections Practice Act, this governs the third-party collection companies. So this is not from the credit bureaus or the original creditors. This pertains to creditors that have purchased an account or defaulted account from the original creditor. All right, so this is what the Fair Debit Collections Practice Act. Now, this is a federal regulation as well. All right, so when we look at the federal regulations, I mean, this one's very simple. It's very, very simple, you know, when it comes to read, and it's 28 pages, but, you know, a lot of this is going to show you, what this means and what that means and so forth. All right, so here it just says that, you know, they can't be abusive to you on the phone. Okay, so they can't misrepresent themselves, and they have to use the existing laws that govern for the Fair Debit Collections Practice Act. All right, so the main thing is in here when it comes to the Fair Debit Collections Practice Act, you know, so we're not going to worry about, you know, some of this stuff in here because, you know, we don't care about the definitions and everything else, and you can read through this yourself. All right, so the main thing in here, you know, they can't communicate by postcard. You know, they have to send a regular letter. They cannot state that a consumer owns any debt. So this is really, you know, for if they call your employer, if they call your family members or anything else, and they say they from ABC Debt Collection, well, this is a violation, you know, because they can't say that you as a consumer owes them a debt or that they're calling from a collection company at all. All right, so this is what pretty much this says in this first part. Okay, so this is so the debt collector has to notify you before they can say, hey, this is a notification from a debt collector, et cetera, et cetera. All right, so here, if they send you an envelope, you know, it can't have, you know, this attorney told us in Washington a couple months ago that they had a hand with somebody upside down and money coming out of them, you know, money falling down, stamped on the front of the envelope, you know, so that's a violation as well. You know, so if there's a window in the envelope, right, nobody can be able to see that it came from, that it's a collection letter as well. All right, so, you know, those are the things that we look for, you know, because we are consumer advocates exercising your rights under federal and state laws. All right, so let's see here. They can't misrepresent themselves, saying that they're an attorney, if they're not an attorney, or that they're calling from a law firm, if they are not calling from a law firm itself, or it's not registered as a law firm collection agency. Now, let me clarify one thing, is that attorneys are still governed by this regulation. Okay, just because they're attorneys, that don't mean they have special rights or anything. The only thing that makes them special is they can file suit against you, and which a regular collection company can too, you know, but usually in it's an attorney that goes to the court hearing to present the case. All right, they can't present at an unusual time. So the time that they're allowed to call you, they're only allowed to call you from 8 in the morning to 9 o'clock at night. And they're only allowed to call you twice a day. All right, so, and this, remember, this is third-party collection companies. All right, so if you tell that collection company that it is inconvenient for them to call you from a certain time to a certain time, then they're not allowed to do that. So usually we'll want to put this in writing, because if you put this in writing, then you have evidence that they've been told. All right, so here's what I say right here, from 8 o'clock to 9 o'clock. All right, and again, inconvenience. Okay, so again, if you tell them it's inconvenient to call you from 8 a.m. to 9 p.m., well, Monday through Sunday or Sunday through Saturday, then technically they're not allowed to call you at all. All right, so just so you know. All right, let's see what else I want to go through here. Communication with third parties. If you have an attorney, then they can communicate with that attorney. Once you let them know, usually they won't speak to you after that. They'll speak to the attorney that you have. Again, they can't contact your employer and tell them that you have a collection or anything else. All right, so here's the cease communications. You can tell them, you can advise not to call you anymore. And there's what they call a cease and assist, which has to do with ceasing all collection activities at all. Then they can't send you a letter or anything else. And by the way, that 8 to 9 o'clock period also applies for emails or any other type of communication. All right. Let's see. This is the harassment and abuse. Again, they can't call you names. They can't say you're a loser because you didn't pay the bill. They can't cuss you out. They can't give you false information, which would be a scam. They can't threaten you with violence. They can't say that you're gonna be arrested, because this is a civil, not criminal. All right. This is the abuse of language that they are reporting here. They can't publicly put it on a website that you owe the debt. So if they put it on a website, like the consumer protection attorney was telling me, he goes, there was one collection company that listed all the people that owe the money. So that's illegal. Let's see, telephone. So again, here's about the no way abuse, harassment of a person. Again, they only allowed to call you twice a day. Now, original creditors are different. Original creditors fall under different regulations than this. All right, a couple other things I want to hit up on. Here is the false representation. They can't falsely represent themselves. Let's see. If you have any questions, stop me and let me know, anybody. Let's see, you can unmute yourself if you're on a phone. Press to the side, or you can unmute yourself, or you can type in your question if you have any questions regarding this. All right, let's see. The main thing that we get into is this unfair practices. All right. So if they tell you say you get a letter saying that you owe a certain amount, right? Well, they have to include the interest, the fees, and everything else as of that date that they sent you the letter of the amount that you owe. All right. So in other words, what I'm trying to get at is, let's say if they send a letter out today and you receive that letter 5 days from now. Well, 5 days from now means that if you had interest and you received the letter, then the amount would be incorrect, because you received it later than they put in there. So that's just, one of the stipulation kind of things to look for. All right, let's see here. We look at all kind of little details, anything that we can use in here. They can't say they're going to take your property by misrepresenting, unless they had a court order, saying that they can do a garnishment or a bank levy or take your vehicle or something like that. So again, that has to be through the court system. They can't just automatically do it. They can't threaten here. as well, about the same thing. All right. So what we do is this right here. It's called a validation of debt. So meaning that the creditor that owns the debt has to validate the debt, the amount owed, the name of the original creditor that the debt is owed. Because sometimes you got two types of collection companies. You got a collection company that owns the debt, and you got a collection company that is collecting on behalf of somebody else, and they don't own the debt. So when they don't own the debt, they have to go back to the original creditor to validate the debt. All right. So, a lot of things that we go through is we look at any of this stuff right here, to see about any kind of violations that we can find. Sometimes we even white letters or whatever that's kind of trick debt collectors, to providing information. It's not really a trick because they're supposed to know the regulations, but it's a trick if they don't know the regulations and they send us something that they're not supposed to. So that's why I say it's a trick. All right, let's see. Again, we have to notify. So when you receive a letter, collection letter, you have a certain amount of days to have that collector validate the debt. Now, if you just see it on your credit report and you ask for a debt validation, you haven't received any kind of letter or anything, then that's different. Okay. So a lot of stuff that we look for on the actual letter itself, it's called a mini Miranda. This is attempt to collect the debt. Any communications thereof will be useful of such. So things of that nature, we look on the letter, we look at the envelope. Here's about multiple debts with a creditor. So we do have consumer protection attorneys that do bring legal action against debt collectors. So what we do is when we think we find a violation, we send it to one of our consumer protection attorneys. And if they want to pursue it, or they tell us, hey, that's good, but do this or the other to get the, to build more of a case, against the creditor. And then when that happens, and then they have enough violations, they file a lawsuit, then they'll contact the client, and the client on that particular account will sign with the lawyer to file suit against the creditor. Now, with that creditor, with the client, there's no charge at all to the client. And if we win the case, the attorney wins the case, then the client is entitled to, the damages that they sued for, and the attorney includes their fees in there as well as a part of the lawsuit action. So that's how they get paid. So everything's upon a contingency. All right, so here again, this is furnishing the set of forms, that I spoke about earlier. So these are the things, you're in a case where you have a individual looking for damage. It's 1,000. You say, oh, well, only 1,000. Well, yeah. It's only 1,000 because it's per thing that's bad. Can you hear me okay, everybody? Yes, maybe. We'll make sure you can hear me. Okay, so let's say you have somebody called you 20 times in a day. Well, that's 20 times the amount, which on calls, it's $500 per call, So on $500 per call, think about it, 500 times 20, you do the math, okay? Let's see here, there's other different things, as far as amounts, as far as them, calling you names and things of that nature as well, okay? So again, this is only 28 pages, and It's very simple to read, unlike some of the other items I'll be going over here in a second. All right, so let's talk about the Fair Credit Billing Act. Fair Credit Billing Act has to do with original creditors. So this makes it more difficult for us as a credit repair company to get items removed from the original creditor. Okay, it's because they fall under different regulations. Okay, so they can call you more than twice a day. They still can't call you before 8 or after 9 or any other kind of communications thereof. You know, so this one's a little bit more complicated to read, but really it's not that bad. You know, so it talks about the Truth in Lending Act. You know, so these are the things that we look for, especially when it comes to foreclosures, you know, mortgages and things of that nature. You know, make sure the escrow was properly done correctly and everything else. All right, so here then it breaks it down, the correction of billing errors. So again, if you see that the amount's incorrect on the credit report from when it was last updated from the creditor, then you know we can dispute that. But again, the creditor can just have it corrected, you know, so that they're reporting accurate information. You know, so they don't necessarily have to delete it at that time. You know, so this has to go with the billing correction as well on that. So it's just, you know, a lot different when it comes to original creditors than third-party collection companies. Now, not all original creditors are the same, you know, so especially when it comes to car loans, you know, so you usually, sometimes you have a servicer, or even a mortgage, you have a servicer and you have the actual company that owns the debt itself. You know, so we look at everything when it comes to how they're reporting and who they are and everything else. There's the regulation on credit reports. It just pretty much says that, you know, everything has to be reported accurately. They can't, you know, may not indirectly or directly or indirectly threaten you, a person, you know, such amount of money can't report it as delinquency to a third party until the creditor met the requirements under the section. Okay, so if a creditor receives a future written notice from any obligator of the amount in dispute, they have to notify the credit bureaus that it's being in dispute as well. All right, let's see. Creditor shall report a resolution of the delinquencies. You know, so what this is pretty much saying that if you come to a payment agreement on a defaulted account and you're making payments, right, on that, well, they should be updating the credit report as well. You know, they have to report on there the length of the billing period. So if you got a 5-year car loan, it's supposed to be reported as a 60-month note. You know, so one of the things that we look at sometimes when an account sold to a third party, that third party will start adding interest. Well, if it wasn't in the original agreement with the original creditor, then they can't do that. That's a violation. All right. So these are the things that we look for. You know, the use of a cash discount. You know, so this is another one that we use. Let's say they say, okay, well, you pay us cash, then we'll give you a discount versus paying with a credit card. Well, then you have to look at that as far as the agreement, see, because this prohibits any such seller from offering a discount to a cardholder to pay with a cash or check or whatever, because the reason they would do that is because they get a fee when they do the swipe or charge for a credit card or something like that. So they'll say, okay, here, pay us a cash or a check, then we'll reduce the amount that you owe, what saves them money to save your money, but they're not allowed to do that as well. All right, let's see here. Just trying to think of anything else I want to go over. Original creditors. Original creditors, you know, again, is a lot more difficult. The regulations is a lot more, you know, say this is 16 pages, the other one's 28 pages. So this is a lot less, you know, but there's a lot of details on here. And all this you can find, you know, just Google the Fair Credit Billing Act, and you can download this PDF. Same thing with the Fair Credit Collections Practice Act. You can download this PDF. Okay, so let's move on to the Fair Credit Reporting Act. The Fair Credit Reporting Act really governs the credit bureaus. Okay, so they're not obligated by the Fair Debt Collections Practice Act or the other acts that we just went over. And as you can see, this is 86 pages. And this is a lot more difficult to read than the other two that we went over. All right, so the reason it's more difficult to read because, you know, it gives them a lot of references, you know, so they'll say, you know, it'll start into something and it'll say reference, you know, USC, this art, you know, this code of compliance 16181 or 1681 or whatever the case may be. All right, so it makes it a lot more difficult to read, but the main thing you have to know is that everything has to be accurate, verifiable, and cannot be outdated. Outdated means it cannot be 7 years old from the time, the date the account went into actual default status. Not from the account was open, but from when the account was put into default status. All right, so when it comes to be accurate, means that when it shows the last reported date from that creditor, so that from that date, the balance has to be accurate, the date open has to be accurate, the account number has to be accurate, everything has to be accurate. If it's not accurate, you have a reason to dispute, you know, which you can dispute with your creditor directly and or the credit bureaus as well. Now, what I mean by verifiable is if you have something on your credit, that credit bureau, and you dispute it, the credit bureau is supposed to have the creditor verify the information. So if that creditor is not in business anymore, then how can they verify it? So then it's got to be removed from the credit. You know, especially with the meltdown of the mortgage meltdown, a lot of them went out of business, and so then we started cleaning up a lot of credit reports that have foreclosures or whatever derogatory items for mortgage companies that were no longer in business anymore. You know, and so when a mortgage company, especially a mortgage company, sells it to another mortgage company, which they're allowed to do, you know, they have to keep the same terms and conditions, but usually within a transition, especially if it's sold multiple times, of course, paperwork and files get misplaced or lost or whatever, and so it's hard for them to actually validate the debt itself. All right, so this is a bunch of information, you know, definition, so to speak. Here's the verification. All right, so, you know, it talks about the verification process as well, you know, which I personally don't agree on because all they're doing is sending an electronic notification through a system called Yosker to the creditor, and the creditor just replies, yeah, it's verified, yeah, it's valid, or not valid, or they do a correction, or they can remove it as well themselves, you know, have the credit bureaus remove it themselves, you know. So where's the actual investigation? You know, did they actually really do an investigation, the creditor? You know, so this is a big issue that's, you know, that consumers have with the whole verification process. All right, let's see. So because the creditors don't have to upload any information or prove it to the credit bureaus. All they do is got to say, yeah, it's valid, and that's it. Okay, let's see here. See what else I want to go over on the Fair Credit Reporting Act. Not a whole lot. Some of the new laws that had came out, one of the new laws that came out is called the National Consumer Assistance Plan that just got put into place, I think about 2 months ago. And so now no judgments and no tax liens will be reported on anybody's credits. Back June or July of last year, they said that judgments had to meet 3 or 4 criteria for it to stay on the credit report. So we probably had about 30, 40%, about 40% of all judgments were removed at that time. But now all judgments are removed completely from the credit. All right, let's see, active duty military, we'll go into that here as well, but they also have additional rights, when it comes to the credit than other people as well. All right, so you might have heard terms called fraud alert. Fraud alert is nothing more than when you tell the credit bureaus that there's potential fraud on your credit. So what the credit bureaus do is put that on your credit report. And so when a creditor goes to get you financing, they're going to see that on there, and they're supposed to validate who you are by asking for your IDs and stuff like that. Now, of course, it's not required for them to do that, so fraud can still go on. The only way to completely protect yourself is to freeze your credit, and that can be really pain, and we'll get into that at a different time. All right, so we have identity theft. Let's see, this is talking about credit and debt related terms. So again, you can see they're talking about the different terms, what they mean, and so forth. This is the permissible purposes of consumer reports. So nobody can just pull your credit report without having permissible purpose, right? So if you're going to do a mortgage loan for somebody, yeah, that's permissible purpose. But if you just want to see their credit report for whatever the case may be, you can't just pull somebody's credit report without their authorization and having permissible purposes to do so. Okay, let's see, anything else I want to go over here? And again, stop me if you have any questions at any time. You can just unmute yourself or type in whatever you want in the chat box. Okay, all right, so let's move on to, this is for military, active duty military personnel. All right, so again, they got additional rights when it comes to their credit. All right, so if they have a car and they're deployed or whatever, and the creditor tries to repo the car, well, then that creditor could be actually get into trouble because they didn't comply with this act, by the federal government. All right, same thing when it comes to default judgment protection, got in here. Let's see what else. So some of the things that we look for, when it comes to active duty military, and we're looking at their credit report, is quite a few things. So such as myself, I was renting a house, renting an apartment before I went into the military. And so I terminated my lease, because under federal regulations, you're allowed to terminate a lease, even if you're in the middle of the lease, if you're going to active duty military. So if they would have came back and put that on my credit that I, broke the lease and I owed them money, that would have been a violation under the federal regulations. All right, so, this gives, say here's the eviction leave installment agreement. Gives them protections under that. If somebody tries to sue them or whatever, it gives them protections under that as well. So if a mortgage tries to foreclose, it gives a protection under that. So, here's about the motor vehicle, where that's taxation, driver's license. So again, with driver's license, just to throw this out there, really don't pertain to credit, but if you're in the military, I was from Georgia, and I was stationed in California. I didn't have to get a California driver's license because I was active duty military, and the state of California had to recognize my Georgia's driver's license and could require me to get a California license. So anyway, there's other financial benefits, protections that they have. You know, if you ever want to know any more information pertaining to this, you know, you can always download, you know, the short acronym is SCRA. So if you just type in SCRA, you can download this PDF and it will give you, you know, show you all the information in here. All right, so, excuse me. So I just want to go through this real quick. Again, we don't just go by federal regulation. States have regulations in place as well to protect their citizens in that state. All right, so depending on where our client is from, you know, we look at the state laws, you know, based off of their situation to see what the state's laws are, to see if we can find violations under state laws as well. All right. So, you know, so I just give you, here's the Children Online Protection Act. You know, I had a case where a lady had, you know, had children, and they actually had medical bills on the children's credit report. You know, if you're under 18, they can't do that. All right. So again, let's see what I want to look through. Okay, here's the Fair Credit Billing Act that we went over earlier. Okay, so again, this has to do, you know, just talks about the same thing that we just went over, you know, here as well. Equal Credit Opportunity Act, meaning they cannot discriminate regardless of race, creed, color, religion, or marital status. You know, so if you tell them you have 10 kids, they can't deny you credit because you have a bunch of kids, you know. So there's a Fair Credit Billing Act. It just kind of, this is kind of like summarized, you know, in here as well. You know, so if you want any of this information I got, just, you know, email me or talk, you know, call or whatever, and I can send you this information as well. All right. So again, here it talks about damages for third-party collection companies that you could get, but it says it can't exceed 1,000, but it's 1,000 per violation, not 1,000 total. So let's just get that clear. Okay. All right. So, you know, this all these different, there's all kind of different regulations. Again, here we use this quite frequently when it comes to medical collections, the Health Insurance Portability and Accountability Act. You know, so if you had insurance and they didn't cover it, or they only covered part of it and they were supposed to cover more, you know, we get into all that stuff according to the regulations here. And you got the Health Protection Act of protecting your medical information. You know, so sometimes we'll send a debt validation out from us showing that we have a power of attorney, and some of these third-party collection companies will send us actual information of medical treatment that the client had. Well, we never sent them a HIPAA release authorization, and so that's a violation. So, you know, just showing you little tricks or things that we do ourselves. All right, here's the Telephone Protect. A lot of people don't know about this. It's called the TCPA, Telephone Consumer Protection Act. Those robocalls you get, hey, you just won, you know, a trip to wherever and everything else. Those are violations, and you can get $500 per call for those RoboForm, or anybody else calling you for that matter, or texting you that you did not get them authorization to do so. So if you get a text, you know, that says, I don't know, you won money or whatever the case may be, and you had no relations with that company, then those are violations under the TCPA. All right, so, you know, so one thing that we used to do is we used to text potential clients, because they contacted us first, And so after they contacted us, you know, we thought, okay, well, that gives us permission to, now we can communicate back with them. But that's not the case. So we stopped that, and now we have what we call ringless voicemail. So our phone doesn't even ring, and they have a voicemail from us, and that's completely, you can do that under the TCPA here. All right, so there's a lot of different statutes, as you can see in here. So I won't go through all those. All right, so the last one I want to really talk about, you know, we'll answer any questions thereafter. So one of the things, again, we look at is the state laws, again. So I just brought this up because we're in Florida. And so, you know, so when we see a repossession on somebody's credit, we look at what state they are and we look up their laws in that state if we don't already know it. So, you know, so this, a lot of states have the same laws like Florida does here when it comes to car repossessions. You know, so here it's just telling you information. So a voluntary repossession and a repossession is the same thing when it comes to your credit, and pretty much the same thing. You just give them a car versus them come and taking it. You know, so it could say voluntary repossession or involuntary repossession on the credit report, but credit scores are still the same. It still acts the same. You know, it's a defaulted account. All right, so when they resell the vehicle after they repossessed it from you, then they have to do it in a commercially reasonable manner. Means they can't sell it to their buddy. You know, you owe $10,000 on a car and they sold it to the buddy for $1,000, and now you're on the hook for a $9,000 on the car. So it's got to be commercially resold. Okay, so they're going to do it in a commercial manner. All right, and then they also got to notify you after they sold the vehicle what they sold it for, and a whole breakdown of any deficiency amounts in there. Okay, so here it tells you, it gives you an example about if they of course they always they sell it for below market value most of the time because they sell at auction and stuff. And so, you know, here they can get a judgment against you for the deficiency of what you owe versus what they sold it for. If what you owe was more. So this talks about that as well. Here's about personal property left in the vehicle and the judgment of the deficiency and so forth. All right, so but we look at all this stuff when it comes to doing credit repair for our clients, you know, and looking for violations of any kind of way that we can find to get items removed from the credit, you know, and even if we can find violations for our clients to actually make money, then, you know, we do that as well. All right, so these are the main ones that we use. I mean, there's some other little ones here and there, but these are the main big boys: the Fair Debt Collections Practice Act, Fair Credit Billing Act, Fair Credit Reporting Act, and then the Civil Relief Act. And then here was kind of a breakdown that I had found that, you know, gives you some kind of, you know, a breakdown of a summary, so to speak, of some of the regulations, you know, that we use. And again, you have state regulations on top of federal regulation, and always federal always trumps state. So when you're looking at state, you know, look at federal and then look at state, because federal always trumps state. All right, if no questions, I'm gonna wrap this up. Any questions? Going once? Going twice? Questions? Type this in. You know, I'll be happy to answer pretty much any question that you have. So if you have any questions, let me know as it pertains to federal, state regulations, violations, anything else. No? Questions? None? you have a question, raise your hand, unmute yourself, put it in the chat box, whatever. Okay, no questions. I'm gonna go ahead and end this. We'll have the next one in 2 weeks. I haven't picked a particular subject that we're gonna be discussing, but if you have any suggestions of what you would like for us to discuss as it pertains to credit, let us know. And we'll be happy to see about discussing that as well. All right, no questions. I'm gonna go ahead and stop the meeting. Have a good night.